Welcome back to the show, viewers. Before the break, we've discussed two of the four cases. One was the enraged cow, the other one was the bushfires. Now, the third of the cases involves a fellow driving along the Geelong-Port Arlington Road, Mr. Ross, who did what, Anna?
So Mr. Ross is driving along and another car approaches him along the side and actually shoots at him, and he sustains gunshot wounds to the side of his body. He's unsure who in the car shot at him, but regardless, someone from that passing car has pulled a gun and shot him.
So it's a
it's
drive-by shooting, Tony.
It's not something that happens every day. I mean, you hardly drive past and say, I don't like the look of this guy, and then you pull a gun and you shoot him. There must have been some history there.
Yeah, and probably more common in the US than Australia. But it does happen, Tony. It's happened many times. Well, look, in this case, it's so they're using the car as a means to do what they've done, and that is drive-by shooting, shoot out of the car. So the question was the car, the use of a car, an incident directly arising from driving of a motor vehicle?
What's the relevance of connecting the incident to a transport accident, Anna?
Well, under Section 35 of the Transport Accident Act, compensation can be paid to people who have sustained injuries in a transport accident. So having your injuries classified as having occurred directly caused by the transport accident means that you've got that compensation available.
So you'll get your loss of income, medical expenses, and any lump sum entitlements, correct?
That's correct.
Okay. Now, Don, what did the court hold in that case?
In this case, the court said it's not a transport accident. They just pretty much said, Tony, that the car was just a platform for the incident. And if we go back to asking that question, if we ask Mr. Ross, what caused your injuries, he wouldn't be saying the car, he would be saying, I was shot.
Someone shot me.
I was shot.
I think it was interesting that the judge commented that the car would be considered within the web of circumstances that has caused the injuries, but it's not the direct cause.
There's no features of the driving, just the car had to be there, Tony. It would be no different if the guy was sitting on the side of the road shooting at people. So in this case, again, if we go back to common sense approach, and it just appeared to be coincidental that there was a car involved.
Seems to be a very, very artificial type of breakup, because if you go back to the first case where the plaintiff won, I mean, it was a cow that knocked her off the bike, Don.
The cow was not only, it wasn't the cause, Tony, and that's the point. It's an incident. It's not the cause, it's just a cause. She was actually on the motorcycle, motorbike, or the four-wheeler quad bike, when the cow hit her or hit the bike, and she toppled over. And in fact, when they couldn't work out exactly, but I think when she went over the embankment, she was still on the motorcycle. So in that case, if we differentiate it to the other cases we've spoken about, she was trying to get away. There was a feature of the driving. Had she not, or the but-for test, had she not tried to get away, but for the cow hitting the bike, the incident wouldn't have occurred.
Well, I reckon if the cow didn't hit the bike, it would have hit her, and she probably would have got more injuries to start with in any place. So I think it's very artificial. Anyway, Anna, there's a case of Hatton. This is a guy that gets hit with the baton or something like that. What's the facts?
Tony, I think these are the club locks. Remember those club locks you put on your car for security reasons?
Yes.
Well, in this case, it wasn't for security reasons. I think it was for protection, Anna.
It sounds like it.
Tell us the facts, Anna.
So what happened in this case, viewers, is that Mr. Hatton was driving along in St Albans, and a car has gone past and cut him off. So he's gestured at the car, and then the car has then subsequently come and rammed him, according to his reports. Then after that, the two drivers have got out of the car, and there's been an altercation, and Mr. Hatton's been bashed with this club lock that Don's described.
Yeah. And what happened, Don? What did the court say?
Well, the court said that it's not a transport accident. It is, again, there was a feature of driving involved. I mean, that's what caused this enraged person. It wasn't a cow, Tony, it was a person. But at the end of the day, the feature of driving had stopped, and what caused the injury in the end was the bashing, or what they used to call the clubbing.
So again, the judge said in this case, if I asked Mr. Hatton what had caused his injuries, he presumed that Mr. Hatton would say, I was bashed. So,
but still, I mean, it was Mr. Hatton driving carelessly or cutting him off, which was a feature of the driving that brought about the circumstances which led to his bashing. Don't you think it's artificial?
But it wasn't the incident that caused his injuries, Tony.
Okay.
So there's going to be an incident directly caused by the driving of a motor vehicle. The driving, it has to be a feature of driving, and that had nothing to do with him sustaining
Okay.
his injuries. It happened afterwards.
We've got 4 examples of people trying to link their incidents to a transport accident to try and get benefits, correct?
That's correct.
Now, the last 2 where there was people being bashed, what the viewers have got to understand is this, and more so to the ones that are doing the bashing, okay, they might not be transport accidents, but there's no reason why the guy that got bashed, Mr. Ross,
That's right.
and also Mr. Hatton, can't sue the perpetrators. Correct?
Well, that's right. I mean, they do have rights, civil rights against the perpetrators, or the assaulters. In Victoria, it's under the Wrongs Act. They're bringing a claim against, or they sue the assailants, Tony, whatever we call them. Now, under the Wrongs Act, Tony, there are, as we know in Victoria, there's all thresholds as to when you can sue.
But not when you get assaulted.
Not when you get assaulted.
No. When you get assaulted, you can just launch into a proceeding, sue them for pain and suffering, loss of enjoyment of life, loss of income, and medical and associated expenses. So the message out there is don't do anything stupid, because at the end of the day, you're going to be held accountable, not to mention the criminal law. Anna, correct?
Yes, well, there's also the criminal law at play, and then it's worth keeping in mind that there's victims of crimes assistance as well for some of these people if it wasn't a transport accident and you were injured in other situations.
And
the courts come down very heavy on people that assault people in these circumstances these days.
as we see many times in the paper, Tony, and we talk about it on this show, you read those articles about sentences being imposed and act as a deterrent as well by the courts. And the other thing, Tony, if a person is charged, then the victim can make a sentence, or charged and convicted, a sentencing act application, which it's not a
Before the sentencing judge.
before the sentencing judge. So the judge who imposes the sentence can also make an award for damages to the victim, which I don't think is used much these days, Tony, but
No, it's not.
it should be an area that should be invoked many times.
I guess, Anna, the problem is when you get before a sentencing judge, they probably don't have enough medical reports and other information to support an application for damages. So that's part of it, isn't it?
Well, I'm sure they'd look at everything they've got before them, so yeah.
And Tony, just going back to what we spoke about today about whether or not it is a transport accident, I think it just goes to show that it's quite important that you speak to a lawyer. There might be circumstances that fall in. I mean, imagine that lady with the enraged cow. She probably thought, I don't have these entitlements. Had she not gone to see a lawyer, she wanted to get all these entitlements.
Well, Don, you've raised a very interesting point, because even in that case of the lady that was in the car with the raging fires, there is a class action on foot, isn't there?
Well, that's right.
Yeah.
I mean, it's another avenue they're pursuing, of course, I assume anyway.
Exactly.
But it's quite important, if you're involved in any incident and sustain injuries, seek some good advice. You just never know.
Viewers, we come to the end of the show. Don and Anna, thanks for coming on board.
Thank you for having us.
Thanks, Tony.
Viewers, thanks for watching. Go to the website, go to the Facebook page, Twitter, and also go back for past episodes, watch our future episodes, and always stay safe.